Good day, ladies and gentlemen. This is Criminal Law, CRJS312, 312. Um, and our textbook is Contemporary Criminal Law. We're on the fifth edition, but my instructional outline is based on the second edition. Um, I've cross referenced it already, and everything lines up. So, I'm teaching good law. Um, so today my lecture is going to be on chapter 8. And before I even get into the lecture, I'll let you guys know up front where the website is. Let's see, get that website. www.sagepub.com/Lipman CCL2e, and that's essentially what that means is Lipman Contemporary Criminal Law, second edition. So you go to that website. Once you go on the website, you look up the student. The student resources. In the student resources, you can go chapter by chapter. They have flashcards. What else? I'm trying to think. Flashcards. They have like an outline for each chapter, so you can kind of know what the basic points are, what you need to take away. And then also, they have quizzes. So if you do those quizzes for each chapter, and you do that throughout the learning this semester, you're going to, I promise you, you're going to see not all the questions, but, and I'm not going to tell you which questions, but you're going to see some of those questions again. So let me get in closer for you. I don't have a zoom on this computer. There you go. All right, now let's dig into chapter 8 real quick. Get this thing going. All right. Chapter 8, we're talking about justifications. Now we're getting into like the defenses of crime. So if you're alleged to have committed a crime, you have a right to defend yourself. One means of defending yourself, or one theory of defending yourself, is having a justification. Essentially, what justifications say is, yes, I did it. Yes, I did it. I committed that act. But I was justified because of the circumstances. So we're going to talk about that. So, of course, I know the first thing that comes to mind for you guys is like self-defense. Like, yes, I shot that man, but I was justified because he was shooting at me. That would be an example of self-defense. Now, as an introduction, we're going to talk about the prosecutor's burden. The American legal system is based on the presumption of innocence until the prosecution proves guilt beyond a reasonable doubt. We know that. The defendant is not compelled to testify or even put on evidence. And they're definitely not compelled to testify against himself, his or herself, and that's, of course, Fifth Amendment or Fifth Amendment right. The prosecutor presents his or her witnesses and evidence in the case in chief. This evidence and the witnesses are subject to cross-examination by the opposing party or the defense. The defendant has the right to introduce evidence challenging the prosecutor's case during the defense's case in chief, or rebuttal stage at trial. The defendant is entitled to file a motion for judgment of acquittal at the close of the prosecutor's case or prior to the submission of the case to the jury. This motion will be granted if the judge determines that evidence is unable to support any verdict other than an acquittal, viewing evidence in the light most favorable to the prosecution. The judge may adhere to the standard procedure of submitting the case to the jury following the close of evidence upon instructing the jury as to the elements of the law and the burden of proof. Now, affirmative defenses. Affirmative defenses are defenses in which the defendant typically possesses the burden of production as well as the burden of persuasion. So this is one of the only times, at least right now, where, in this portion of our learning, where we talk about the defendant actually having a burden. So the prosecution only has the burden of trying to prove guilt beyond a reasonable doubt. They're not obligated to prove our innocence or make our case for us. Remember, they're the opposing side. So, if a defendant did commit an act but did so in self-defense, it's the defendant's job to bring, if we're in trial, it's going to be the defendant's burden to bring that up. The prosecution doesn't bring it up for him. So that's why it's called what we call an affirmative defense. It's a defense in which the defendant has the burden of proving it. Meaning that if it's going to come up, that means if we're going to bring it up as our theory of the case to try to fight the prosecution's case, we have the burden of bringing it up. They're not going to bring it up for us. In addition to attempting to demonstrate that the prosecution's case suffers from failure to prove beyond reasonable doubt, the defendant may present affirmative defenses. Justifications and excuses are both affirmative defenses. The burden is now on the defense to prove these affirmative defenses, and they have to prove it. The burden on the defense to prove the affirmative defenses is the preponderance of the evidence burden of proof. So the defendant in bringing up the burden and having the burden of proving an affirmative defense does not have that same high burden of proof that the prosecutor has to prove guilt. The burden of proving an affirmative defense is for the defendant is only by a preponderance of the evidence. In other words, it was more likely than not. So but that doesn't change the prosecution's burden of proof. They're always gonna have that burden of proof. If they're gonna prove you guilty, that burden of proof stays high, and that's at beyond a reasonable doubt. But as a defendant, if a defendant wants to say, "Hey, I did it, but I was justified because I was defending myself," then of course the defendant has the burden of bringing that up and presenting evidence to prove it. But all they have to do to prove it is prove it by preponderance of evidence and not by that same high burden that the prosecution has to prove guilt. There are two types of affirmative defenses that result in acquittal. Of course, this chapter is going to focus on justifications, but it's justifications and it's excuses, and we'll get to excuses in chapter 9. But justifications, these are defenses. These are defenses to otherwise criminal acts that society approves and encourages under the circumstances. Like I said, you're essentially saying, yes, I did it, but I was justified in taking the act based upon the circumstances I was in. An example would be illegally parking in front of a hospital in an effort to rush a sick infant into the emergency room. Justification speaks to the rightness of the act. Like, yes, I took the act. The actus reus was done. But we're going to negate. But the mens rea is kind of irrelevant because of the circumstances. I had to do that because of the circumstance that I was in. At common law, justifications resulted in an acquittal. Of course, there are various theories for defense justification. Of course, you have a moral interest. Acts are justified based upon protection of an important moral interest. You have the superior interest in being preserved outweighs the interest of the person who was harmed. A more compelling value. Public benefit. An act is justified on the grounds that it is undertaken in service of a public good. Law enforcement officers use force to protect the public. And that, of course, that's for public benefit. Then you have moral forfeiture. Individual perpetrating a crime has lost the right to claim legal protection. This explains why a dangerous aggressor may justifiably be killed in self-defense. So in other words, if a person is an aggressor, they kind of forfeit their morals. So once you become an aggressor, you've now forfeited the ability to now be protected. So that means whoever you're being an aggressor to now has the right to return the force that you're threatening them with. So we talked about justifications. Now we're going to talk about, of course, the whole chapter is about justifications, but we're kind of brushing over excuses. So we're going to talk about excuses, which is the second affirmative defense. These are defenses to acts that deserve condemnation. So yes, you did it, but for which the defendant is not held criminally responsible because of a personal disability such as infancy, which is being underaged, or insanity. An example would be illegally parking in response to the delusional demand of voices in your head. So we talked about those the illegal parking hypothetical. In the first hypothetical, you illegally parked in front of the hospital because you were rushing a sick child to the emergency room. In the second example, you were illegally parking because the voices in your head told you to park there. So in both situations, those are defenses. One is saying, yes, I did it, but I was justified. The other one says, yes, I did it, but the the voices in my head told me to. So in other words, there's a question of whether or not you were insane or not. So we talk about excuses, especially in insanity defenses. A lot of times that's when the mens rea portion of the crime is in question. So in other words, based upon your mental state, could you have even had the mens rea? And when we get to excuses, we'll talk about that in chapter 9. The excuse speaks to whether the actor is mentally accountable for a concededly wrongful act. At common law, excuses did not result in acquittal, but resulted in a mitigated sentence or exemption from death penalty. Perfect defense, where the individual is able to satisfy each and every element of a justification and is acquitted. An imperfect defense. These are instances in which the requirements of the defense are not fully satisfied. An example: excessive force used in self-defense. So, someone may be threatening you, but they're threatening you based, that they're essentially putting their hands up and swinging at you, trying to punch you, but you pull out a knife and cut them. At that point, you had a right to defend yourself. Your defense wasn't proportionate to the threat that was issued against you, and we're going to talk about proportionality in a minute. So you're going to be justified, but not all the way justified. So that's what we call an imperfect self-defense. So you're still going to so your case isn't going to 100% go away. You're still going to be possibly held criminally responsible because you just upped the ante. In most cases, by pulling out a knife in a fist fight, even if you're not the initial aggressor, you've now swapped places and you are an aggressor because you've taken it to the next level. And we'll talk about that in a minute. Then we also have what we call mitigating circumstances. So when you do have an imperfect defense, in that situation, even if a defendant is not going to be 100% exonerated or acquitted based upon his justified action because he may have gone too far, the fact that he or she is not the initial aggressor and they even had to act in justification can at least be used to mitigate the punishment. Mitigate meaning making better. Evidence that is not relevant for justification or excuse may still be relied on during the sentencing stage as a mitigating circumstance that may reduce a defendant's punishment. A defendant's good motive in committing a mercy killing of several sick family members may not be considered in determining guilt or innocence and is only considered at sentencing. Then we have jury nullification, and that's essentially a situation where the jury, we're dead in the middle of trial, and now the jury has to make a decision on guilt or innocence. But even though you may not be perfectly what we call legally justified in your actions, the jury may still understand and may want to acquit you anyway, because the jury does have a right to ignore the law. Where a jury is presented with evidence that makes them disregard law, and this is the evidence. This is the definition of jury nullification. This is when the jury is presented with evidence that makes them disregard the law and make a decision based upon emotion. And that decision based upon emotion can only be made to acquit a person. It can't be made to convict a person. So convictions, like I said, because there's the burden of proof beyond a reasonable doubt. For a conviction, a jury must be fully satisfied and entirely convinced that all of the burdens, but all of the elements of the crime were met. So that they can't waver from that, and they can't make an emotional decision when they're convicting somebody. But they can, however, make an emotional decision when they're acquitting somebody, when it's the opposite, when they're saying this person isn't guilty or they're justified in their actions. Judges are not required to instruct the juries on the power of nullification. They usually only instruct to strictly apply the law. Self-defense and individual self-defense, and this is the first justification, and it's the one the first one that comes to mind. An individual may use physical force in self-defense or defense of oneself. Someone's attacking me, that means now I can use physical force to protect myself. The central components of self-defense. First and foremost, there must be a reasonable belief. So it is an objective standard. And we talked about in earlier chapters what objective is as opposed to subjective. Objective means we're talking about that reasonable person. In other words, what the reasonable human being, not you as an individual, but what a reasonable human being would do in a situation. When we talk about subjective, we're making that individual person, me, for instance, the subject. In other words, what would Boyce do, given who Boyce is and what Boyce's background is, what was right for him to do. So you see, one is like a standard reasonable person, and the other is you, who this person is. They take this person as an individual and their background to determine if what they did made sense. So anytime you hear the word reasonable belief, that is a telltale sign that we're talking about an objective standard. So when you hear the word like reasonable person or reasonable belief, that's the key word that lets us know we're talking about an objective standard. The central components of self-defense. First, we must have a reasonable or objective belief. An individual must possess a reasonable belief that force is required to defend him or herself. The individual must believe, and a reasonable person must believe that the force is required in self-defense. So you have reasonable belief, then you have necessity. So that means you're acting out of necessity. The defender must reasonably believe that force is required to prevent an imminent and unlawful infliction of death or bodily harm. So that means not only is it's a reasonable belief, but it's out of necessity. It's right now and it's imminent. It's about to happen. So a lot of times, the one thing that hurts self-defense claims is time. So if something happens and a person waits, almost the longer you wait, the more likely the person is going to lose that justification of self-defense. Because self-defense doesn't mean you hit me at 2:00 and I got to wait and think about it until 4, and then I got to come back and hit you. And hit you back. Self-defense means it has to be done out of necessity and imminence. In other words, it's something that was necessary to protect myself right now. So you're swinging at me, and I swing back, or I block it and swing back, and I protect myself. So you got reasonable belief, necessity, and then third, you have proportionality. And this is the important thing. I kind of mentioned it a few paragraphs or sentences back. The force employed must not be excessive or more than is required under the circumstances. What that means, you can only use the force that is proportionate to the force that's being used against you. If someone is throwing punches at me, what I do in return has to be proportionate. It doesn't have to be equal. So there's difference between proportionality and equality. Because if someone punches at me and I kick them back, that is still proportionate. It may not be equal. In other words, it's not a punch for a punch. But it's me not having a weapon and using my body to protect someone that's using their body to be an aggressor towards me. The same thing if someone charges me and is swinging at me trying to punch me, I can't pull out a baseball bat because now the I'm no longer proportionate because the baseball bat is now taking it to the next level. Now in that situation, I've now become the aggressor. Because the force I'm using is now disproportionate. So it doesn't have to be equal, but it does have to be proportionate. So if someone pulls a deadly weapon on me, I'm allowed to use a deadly weapon to defend myself. because it's proportionate. It doesn't mean I have to use the same deadly weapon, but I have to use a deadly weapon. Like I have, but I can. I don't have to say can't have to, but I can use a deadly weapon. So if in the instance, and I got cases I'm working now where a person was, if a person is being charged by a car, someone's trying to run into them, they're walking, and someone drives a car or tries to run them over with a car, and they pull out a gun and shoot at the car to essentially defend themselves, they are justified. The force they use isn't equivalent. It's not like, they're required to go, okay, a person trying to charge me with a car, so the only thing I can do to defend myself is go get in the car myself and charge them back. No, because remember, it has to be imminent out of necessity. But I am allowed to use deadly force because the force they're using is likely to kill me if they're successful. So I'm allowed to use deadly force. So it's just about proportionality. So a deadly weapon versus a deadly weapon. Um, so we always talk about bringing a knife to a gunfight. It's essentially bringing a weapon to a weapon fight. So if someone is now challenging me with something that can kill me, I can now challenge them with some. I can now defend myself with something that could kill them. In other words, so like I said, it's not about equivalence, but it's about proportionality. Then we have retreat. In certain jurisdictions, so we're talking about the elements of what's needed for self-defense. You got a reasonable belief that you're in danger. You acting out of necessity and imminence. The force you use must be proportionate. And in certain jurisdictions, they require that you at least try to retreat. In other words, you defending yourself has to be a last resort. So a defendant may not resort to deadly force if he or she can safely retreat. So those are in retreat states or retreat jurisdictions where they say, well, if it's a non-deadly force and you're returning a non-deadly force, then you don't have to try to retreat. But if you're using deadly force in a situation, some states require that you at least try to retreat or see if there's another means of getting out of the situation before you resort to deadly force. I think that's unreasonable because in real life, if someone's using deadly force, you don't have time to think about that. You see a gun, you pull a gun. That's why. And then you're talking stand your ground states. They don't even require under any circumstances that you retreat at all. So in other words, someone challenges you a certain way or pulls a deadly weapon on you, and you have a right to pull a deadly weapon on them and use it. Is generally not required when the attack occurs the retreat doctrine is generally not required when the attack occurs in the home or workplace, or if the attacker uses deadly force. Of course, if the attacker uses deadly force, you don't got to think about it. You just get to use deadly force automatically back. When you're in your home, you shouldn't be made to have to find another means of protecting yourself in your home. You don't have to think of any other options outside of deadly force. So if deadly force is used against you in your home, or there's a threat of deadly force, or you have a reasonable belief that deadly force is going to be used against you, you can use deadly force to protect yourself. As a matter of fact, in most homes, imagine being asleep. It's 2 a.m. You sleep. You hear some rumbling and fussing. Somebody kicks your door down. At that point, you get to pull a gun. You pull a gun because you don't. In that situation, the mere fact that this person is breaking into your home, particularly in the nighttime, but not even particularly breaking into your home at any time. You don't have to figure out what they're trying to do to you before you respond. You can immediately go directly to the gun because they've now broken into your house, and you don't have to try to run and hide. There's no obligation to try to retreat. You can use deadly force immediately. Then we talk about then next after retreat, we talk about the aggressor. An aggressor or individual who unlawfully initiates force generally is not entitled to self-defense. So to be entitled to self-defense, you cannot be the aggressor. You can't start a fight and then claim that you were defending yourself. So in other words, you have to be responding to a threat, not being the initiator of the threat. You may only claim self-defense in those instances that an aggressor who is not employing deadly force is him or herself confronted with deadly force. So, and I talked about that a few minutes ago. So, let's say if someone is attacking me, but they're attacking me with their hands, they're trying to fight me or punch me, um, and I have every right at that point to defend myself. But in defending myself, I pull a weapon, I pull a gun. At that point, we've now switched places, and I'm the aggressor because I've now taken it to another level. So I'm now the aggressor. So I don't get to claim that self-defense anymore once I become the aggressor. Even though I was the initial, I wasn't the initial aggressor. I changed into being the aggressor once I pulled a weapon. Some courts require that under these circumstances, the aggressor withdraws from the conflict, if at all possible, before enjoying the right to self-defense. Some courts allow an aggressor who employs deadly force to regain the right to self-defense by withdrawing from the initial attack. The other party then assumes the role of the aggressor. So sometimes the aggressor can change in certain situations depending on what the other side does. Then we talk about mistake. An individual who is mistaken concerning the necessity of self-defense may rely on the defense so long as his or her belief is reasonable. Then we talk about imperfect self-defense, as we talked about a little bit before. An individual who honestly but unreasonably believes that he or she confronts a situation calling for self-defense and intentionally kills is held liable in many states for an intentional killing. The imperfect self-defense rule provides that although the defendant may not be acquitted, fairness dictates that he or she should be held liable only for the less serious crime of manslaughter. So you're still, if it's an imperfect self-defense, it doesn't mean you're not going to walk away, but you're also not going to be shouldn't be convicted for the most serious charges because it's an imperfect self-defense. And when we look at the totality of the circumstances, we find that you might have been justified in taking action, but you weren't perfectly justified you weren't justified to use the exact type of force you used. So therefore, you're still in trouble. You're just not in as much trouble. Model Penal Code, the basic formulation affirms that the use of force the use of force is self-protection, and self-protection is justified in those instances in which an individual employs it in the belief that it is immediately necessary for the purpose of protecting himself against the other's use of unlawful force on the present occasion. An aggressor that uses deadly force may retreat and regain privilege of self-defense against the other party. So that's another thing. If someone, we talk about becoming an aggressor, someone is now the aggressor and they're coming towards you, and you start to fight them, and let's say you get the best of them, and they say, "Okay, I'm done," and they try to get away. The moment you now start chasing them, now you become an aggressor. So the whole point of self-defense is just to get yourself out of that immediate trouble, or reasonably immediate trouble. The word immediate is going to be relative to whatever the situation is. So the second edition, of course, they have those great equations. Self-defense equals a reasonable belief plus immediately necessary plus employ proportionate force plus to protect against to protect oneself against unlawful force. So that is self-defense. We'll talk about a case or two. Okay, let's go. State v. Haberman. Defendant argued that the trial court erred in convicting him for second-degree murder or second-degree assault by refusing to instruct the jury on self-defense. The appellate court found that the defendant presented evidence that he was not the initial aggressor in the attack upon him by the victim, the credibility of which was up to the jury to determine. The defendant presented evidence that he tried to escape from the alleged attack by hitting the person in order to get him off of him. Because this was not successful and defendant feared serious bodily harm, he pulled out his knife to get the person off of him. There was substantial evidence to support the giving of a self-defense instruction. So the trial court was found to have been in error. So the trial court guilty verdict was reversed. So in other words, in trials, as long as a person can put forth evidence of self-defense, and they meet the certain requirements, then it has to go. The jury has to be notified that they can consider self-defense as a defense, as an affirmative defense to determine guilt. Then we have another case, State v. Marshall, and essentially what that case says is that hold on. Okay, it says, in defending oneself, one could not use more force than was reasonably necessary, or that essentially this is a case about proportionality. Okay, now let's go on to reasonable belief. What's that mean? Most jurisdictions, the common law and modern, require an individual who relies on self-defense to act with a reasonable belief in the imminence of serious bodily harm. That means it must be based on reason, that objective reasoning, and it must be imminent right now. So in other words, it's not he hit me at 2:00 and I got mad, thought about it for 2 hours, and said, you know what, he pissed me off, I'm gonna go hit him back. That's not self-defense. Self-defense, we're talking about imminence. It has to be imminent, meaning that I'm protecting myself from a right now situation. Reasonableness has two prongs. The subjective prong, I know this is objective and subjective, but the subjective prong, in the subjective situation, the defendant must demonstrate an honest belief that he or she confronted an imminent attack. Then two, the objective portion is the defendant must demonstrate that a reasonable person under the same circumstances would have believed that he or she confronted an imminent attack. So in determining whether what someone does as reasonable, whether it's reasonable or not for self-defense, we have to look at it. So the first question is about this person, the situation they're in particular. And then the second question is what a reasonable person would do in a similar situation. So it's both subjective because you're looking at where this person is and what their current present situation or what their situation was, and then you're applying an objective standard to say, okay, what would a reasonable person in that same situation do? An individual who acts with an honest and reasonable but mistaken belief that he or she is subject to an armed attack is entitled to the justification of self-defense. The Model Penal Code adopts a subjective approach and only requires that a defendant actually believe in the necessity of self-defense. This approach has been adopted by very few courts. The subjective looks into the individual's head to determine what was reasonable. The subjective approach is based on the individual's natural right to self-preservation, which is not based on what a reasonable person would do. So the Model Penal Code doesn't even have an objective part. It just says, what would you do? And how did you feel? A number of courts are moving to a limited extent in the direction of the Model Penal Code by providing that a defendant acting in honest but unreasonable belief is entitled to claim imperfect self-defense and should be convicted of a lesser offense. Let me see if I want to go over this case. Okay, Harshaw v. State. The defendant and victim were arguing, and the victim threatened to retrieve his gun. They both retreated to their cars, and the defendant grabbed his gun in time to shoot the victim as he reached inside his car. The victim was later found to have been unarmed. The court ruled that the judge should have instructed the jury on manslaughter because the jurors could reasonably have found that Harshaw acted hastily and without due care, and that he merited a conviction of manslaughter rather than murder. So that's what came out of the Harshaw case. We won't pass some of these cases. Imminence. A defendant must reasonably believe that the threatened harm is imminent, meaning the harm is about to happen. So it's a right now situation. It's not a wait. Um, it's not a after it happens, then get mad, wait 4 hours and get mad, and then come back to get revenge. So self defense is not about vengeance. It's about defense, right? Imminent defense against an imminent harm. The requirement of necessity is based on several considerations. For one, resolution of disputes. The law encourages the peaceful resolution of disputes where possible. So if it's not imminent and you had time to make it right, or try to resort to something else or an alternative, then if we didn't require imminence, then people would essentially get to say, he hit me 4 hours ago. I'm offended by getting hit, so I'm gonna go shoot him back and claim self-defense. Last resort. Individuals should only resort to the self-help where strictly required. Evidence. The existence of a clear and measurable threat provides confidence that the defendant is acting out of self-defense rather than out of desire to punish the assailant or to seek revenge. The existence of clear threat assist in determining whether there is a proportionality between the threatened harm and the defense response. Okay. Okay. We have State v. Schroeder. A 19-year-old defendant stabbed a violent cellmate who threatened to make Schroeder his sex slave or punk. Schroeder testified that he felt vulnerable and afraid and woke up at 1 a.m. and stabbed his cellmate in the back with a table knife and hit him in the face with a metal ashtray. The Nebraska Supreme Court ruled that the threatened harm was not imminent and that there was a danger in legalizing preventative assaults. So he was found guilty. Other courts have not always insisted on a strict imminent standard. The Model Penal Code adopts this type of approach and provides for that force is justifiable when the actor believes he or she will be attacked on the present occasion rather than imminently. This standard would permit individuals to employ force and self-defense to prevent an individual who poses a threat from summoning reinforcements. So it kind of makes sense. One should not be expected to remain continuously on guard against an assault his older cellmate or his cellmate's friends. Hold up. All right, and this is an important case. State v. Norman. In the case of the defendant argued that the trial court erred when it failed to instruct a jury on self-defense. The state argued that the trial court did not err because the defendant was not entitled to jury instructions because her husband was asleep when the defendant shot him. The court held that the trial court erred when it failed to instruct the jury on self-defense, on perfect self-defense. The court noted that the facts of the case presented the question of whether the victim's passiveness at the moment he was killed precluded the defendant from asserting the defense of perfect self-defense. The court found that the evidence was sufficient to have submitted the issue of perfect self-defense to the jury. The court noted that based on the facts and the expert testimony, the defendant suffered from battered spouse syndrome, and that the abuse was so severe and had continued for so long that the defendant met both the subjective and objective aspects of the perfect self-defense test. The court noted that the jury should consider evidence of battered spouse syndrome along with all the evidence when it considered whether there is a reasonable doubt as to the unlawfulness of the defendant's conduct. The court reversed the trial's judgment, which convicted the defendant of killing her husband and remanded for a new trial, and instructed the the trial court to give the jury instruction of perfect self-defense. So in that case, that's a case that allows a person to not have to be facing imminent danger. So essentially, because this woman was being beaten every day and she was a battered spouse, the court essentially said if she's a battered spouse, then she's pretty much always in danger anyway. She just decided to protect herself when she was the least vulnerable, which is while her husband was asleep. Excessive force. An individual acting in self-defense is entitled to the use of force reasonably believed to be necessary to defend himself or herself. Deadly force. This is force that a reasonable person under the circumstances will be aware will cause or create a substantial risk or substantial bodily harm. The application of excessive rather than proportionate force may result in the defenders being transformed into the aggressor, as I said before. So let's move on. Let's see. Not gonna worry about that case. Then we talk about retreat. The principle of necessity dictates that every alternative should be exhausted before the individual resorts to deadly force, and that an individual should be required to retreat to the wall as far as possible, unless, of course, it's use of deadly force. Virtually every jurisdiction provides that there is no duty or requirement to retreat before resorting to non-deadly force. So what's that mean? That means if it's non-deadly force, you don't have to retreat. Or if the force you use is non-deadly, then you don't have to retreat. A majority of jurisdictions follow the same stand your ground rule in the case of deadly force, although a significant minority require retreat to the wall. Stand your ground is based on several considerations: the promotion of a courageous attitude, the refusal to protect a wrongdoer initiating an attack, the reluctance of courts to complicate their task by being placed in the position of having to rule on various issues surrounding their duty to retreat, and the retreat rule may endanger individuals who are required to retreat and encourage wrongdoers who have no reason to fear for their lives. So that's the retreat. Let me see. Okay, most jurisdictions limit the right to stand your ground when confronted with non-deadly force to an individual who is without fault, or called a true man. So you can't be an aggressor and then claim that you deserve defense in the situation unless it's the force changes. An aggressor employing non-deadly force must clearly abandon the struggle, and it must be a withdrawal in good faith to regain the right to self-defense. So I can start off as the assailant or the aggressor, then try to retreat, and once I'm like, I'm done, I want to quit, and then they follow me. Then at that point, now they are the aggressor, and if I shoot at them, I'm now defending myself. All right. The requirement of retreat is premised on the traditional rule that only necessary force may be employed in self-defense. Let's move on here. The castle doctrine and domestic violence. So the castle doctrine essentially says you don't have to, if you're in your home, you don't have to retreat. You can protect yourself with whatever force is necessary in your home, even deadly force, of course. Minority states impose a duty to retreat on an individual in his or her own home in those instances in which the individual is assaulted by a cohabitant. So if someone is from outside my home is trying to come in, of course, at that point, the castle doctrine applies, and I get to essentially shoot them or use deadly force. Now, if someone that lives within the home with me is attacking me, then at that point I have to try to leave. The castle doctrine in that situation doesn't apply, and that's in a minority of states. State v. Gartland. A wife kills husband after he threatens her and approaches her in the bedroom. She shot him as he lunged at her. Defendant was convicted at trial. Defendant did not have the exclusive right to occupy her bedroom, and that the victim had regular access to the room. So in other words, the trial court said that, of course, because the person that was allegedly attacking her was in the house, she had the obligation to leave before using deadly force, but she didn't. That's what the trial court said. As a consequence, the defendant possessed a duty to retreat so long as this could have been safely accomplished prior to resorting to deadly force. Jury instructions that the jury should consider whether the defendant could have safely retreated from the home should have been tailored to the specific facts of the case. The jury should have been instructed to consider whether the defendant could have safely made her way out of the bedroom while armed with the gun. So that's a situation where castle doctrine doesn't apply when you're when your assailant is someone that's in the house that lives in the house with you. Now that's that jurisdiction. State v. Glowacki. The obligation to retreat from the home would confront women victimized by domestic violence with the difficult choice of abandoning their children. So of course in that situation, the castle, in that jurisdiction, they didn't apply the castle doctrine. So we've talked about self-defense ad nauseum, right? Now let's talk about defense of others. At common law, it limited the privilege of intervention in defense of others to the protection of spouses, families, employees, or employers. This is based on the assumption that an individual would be in good position to evaluate whether the individuals were aggressors or victims in need of assistance. The prevailing or modern view, what we apply now, a person is justified in threatening or using force against another when he or she reasonably believes that force is necessary to defend himself or another person against such others' imminent use of unlawful force. So in other words, in modern law, I'm allowed, no matter who the person is, doesn't have to be my spouse, family, or employee or employers. No matter who the person is, if I see they're in peril, I can go in and save them. I can at least try to go in and save them and use force to do so. The alter ego rule. An individual intervening stands in the shoes or possesses the same rights as the person whom he or she is assisting. So if someone's being attacked with a gun and they're about to be shot, I'm allowed, as the third party coming in to save that person, I'm allowed to become the person I'm saving. So it's a question of what they can do in their present situation. So the alter ego rule says I can use whatever force they could have used to defend themselves. That's all it means. Objective test for intervention in defense of others. An individual is justified in using force to protect another whom he or she reasonably believes, one, is an immediate danger, two is entitled to such protective force in self-defense, three, such force is necessary for the protection of the other person, four, the intervener is not criminally liable under the test for a reasonable mistake of fact. This test protects individuals who act in a reasonable but mistaken belief. Got a case there, People v. Young. Okay, People v. Young. Two plainclothes detectives arrested a teenager from blocking traffic. The defendant intervened and hit one of the two white men who were pulling on the black teenager. The defendant was convicted under the alter ego rule for intervening to defend an individual who, in fact, did not possess the right to self-defense. The New York Court of Appeals affirmed the conviction, but asked what public interest is promoted by the principle which would deter one from coming to the aid of a fellow citizen whom he is responsible, who he is reasonably has reasonable grounds to believe is in imminent danger of a person, of a personal injury at the hands of an assailant. So that essentially reversed that. Let's see. Sorry about that. Hold on. It's up here. Okay, so the legislature responded by modifying the law and making it an objective test. Sorry about that. Then we have defense of the home. The home has historically been viewed as a place of safety, security, and shelter. At common law, the right to use deadly force in those instances in which they reasonably believe there was a reasonable belief that his force is required to prevent an injury, an imminent and unlawful injury to his home. The common law rule is sufficiently broad to permit deadly force against a rapist, burglar, a drunk who mistakenly stumbles onto the wrong house on his way to the surprise birthday party. States gradually abandoned the common law approach and adopted statutes that restricted the use of deadly force in defense of the home. Um, you, the uniform modern approach it limiting deadly force to those situations. It limits deadly force to those situations in which deadly force is reasonably believed to be required to prevent the entry of an intruder who is reasonably believed to intend to commit a felony in the dwelling. So of course, if someone's breaking in your house, you shouldn't have to ask them what they plan on doing. You're allowed to assume they're going to do something bad. Other statutes strictly regulate armed force and only authorize deadly force in those instances in which a reasonable belief, it is reasonably believed to be required to prevent the entry of an intruder who is reasonably believed to intend to commit a forcible felony involving the threat or use of violence against the occupant. Make sure. There's some cases here. Then next we have the execution of public duties, and this is with officers, because with police officers, of course, um, they're allowed to use force. Um, the enforcement of criminal law requires that the police detain, arrest, and incarcerate individuals and seize and secure property. This interference with life, liberty, and property would ordinarily constitute a criminal offense. The law provides a defense to individuals executing public duties. This is based on the judgment that the modern public interest in the enforcement of law justifies intruding on individual liberty. Employment of deadly force by police officers in arresting a fleeing suspect. There's actually a case on that. Tennessee v. Garner makes it illegal for police to shoot a fleeing suspect. So if this suspect's run away, has his back turned, they can't use deadly force. The police officer is a minister of justice and is entitled to a particular protection of the law. Without submission to his or her authority, there is no security and anarchy reigns supreme. This is what the book says. Um, only reasonable force could be applied to apprehend a misdemeanor. It is considered inhumane for police to employ deadly force against individuals responsible for minor violations of the law. So, of course, the fleeing felon rule states that it's the rule permitting the employment of deadly force against fleeing felons that was developed prior to the arming of police with firearms in the mid 19th century. So there used to be a what they call the fleeing felon rule, but of course Tennessee v. Garner made that unconstitutional. If a person's running from law enforcement, they can't just shoot them in the back. Let me see. One of the main reasons to have to limit the use of deadly force to apprehend suspects is, for one, it turns the police officers into like the judge and jury right there. They're essentially now they've judged the person guilty, and they sentenced him to death in one fell swoop. So that's one main reason why they want to keep that from happening. And you gotta believe also, not even believe, we know police officers are humans too, so they're subject to frailty, and they're subject to making mistakes. So why allow them to make a mistake that could, take somebody out of here? You have the model penal code. The use of force towards another person is justifiable when the actor is making or assisting in making an arrest, and the actor believes that such force is immediately necessary to effect a lawful arrest. Alrighty, skip this stuff. So deadly force during arrest equals fleeing felon rule plus law enforcement officer and or civilian acting under law enforcement direction. Felony arrest plus no substantial risk of injury to innocence. Felony involves threatened use of deadly force. Substantial risk of serious injury or death if apprehension is delayed and the warning was feasible. Resisting unlawful arrest. Common law / English rule recognized the right to resist an unlawful arrest by reasonable force. It did not provide a defense to the murder of a police officer. If the officer had no right to arrest, the other party might resist the illegal attempt to arrest him using no more force than that was absolutely necessary to repel the assault constituting the attempt to arrest. The American rule: an individual may not resist an illegal arrest. So that's the general rule. Of course, in some jurisdictions and states, you're allowed to resist an illegal arrest, but in America, for the most part, you just got to get arrested and then fight it in court. But this is based on the fact that those charged with crimes have more rights and aren't subjected to the same tortures and hardships of imprisonment that used to be in the common law days. So a lawful arrest or unlawful arrest does not allow resistance by physical force. Excessive force in an arrest equals proportionate self-defense. State v. Hobson. Then next, as an affirmative defense, we have necessity. The necessity defense recognizes that conduct that would otherwise be criminal is justified when undertaken to prevent a significant or more harmful or significant, or I would say more harmful harm. It's called the choice of evils because individuals are confronted with the unhappy choice between committing a crime or experiencing a harmful event. Traditionally, the harm to be prevented was required to result from the forces of nature. Example: a boat captain caught in a storm docking his boat on a pier with no trespassing sign. So of course it was, act of God. If a storm is dangerous, so even though I'm not allowed to trespass here, I need somewhere to lock my boat up because and not move because otherwise I'll be in danger. In modern law, the limitation of necessity to actions undertaken in response to forces of nature has been modified. Most modern cases arise in response to pressures exerted by social conditions or events. Reasons for defense of necessity. Respect. You want to punish individuals under these punishing individuals under these circumstances will lead to disrespect for the legal system. Equity. Necessity is evaluated on a case-by-case basis and introduces flexibility and fairness into the legal system. So when we talk about the defense of necessity, it's essentially looked at on a case-by-case basis. One example of necessity would be you're at a club, you've been drinking, you have a let's say you have a designated driver, then someone wants to fight you in the club, and you get out in the parking lot, and this person pulls a gun on you, and your only option is to either stay there or get in your car and drive off, even if you're intoxicated, but you're driving away from a harm. That would be an example of where the necessity defense would be used. Let's see. Then then we have consent. The fact that an individual consents to be the victim of a crime ordinarily does not constitute a defense. Although an individual is not criminally responsible for self-abuse or for taking his or her own life, those who assist him or her are criminally liable. Criminal law punishes acts against individuals that harm and threaten society. The fact that an individual may consent to a crime does not mean that society does not have an interest in denouncing and deterring this conduct. State v. Brown, a New Jersey court ruled that a wife's instructions to her husband that he was to beat her in the event that she consumed alcoholic beverages did not constitute a justification for the severe beating he administered. To allow an otherwise criminal act to go unpunished because of the victim's consent would not only threaten the security of our society, but also might tend to detract from the force of the moral principles underlying criminal law. 3 exceptions to situations in which law recognizes consent as a defense to criminal conduct. Incidental contact. Acts that do not cause serious injury or harm customarily are not subject to criminal prosecution and punishment. An example would be people are often bumped and pushed on a crowded bus or in a nightclub. So you're always brushing past people, so you touch them. It's not an assault. They're not allowed to. Of course, you're kind of justified because everyone being in that situation is kind of an automatic consent to be touched. Then you have sporting events. Ordinary physical contact or blows that are incident to sports such as football or boxing. That is consent, or wrestling. Socially beneficial activity. Individuals benefit from activities such as medical procedures or surgery. So a doctor isn't going to be charged with assault for doing a surgery on you, an emergency surgery or something like that. An individual may also limit the scope of consent, for instance, only authorizing a doctor to operate on 3 of 5 of his fingers on his hand. So they can limit the scope of consent. Consent is generally not a justification, just to get that clear. Someone saying, yeah, sure, you can punch me, is never going to go well in court. Consent equals justification for a minor physical injury, only minor physical injuries, foreseeable injury in a legal sporting event, or beneficial medical conduct, plus consent is voluntarily given by an individual with legal capacity. So that's where consent comes in. So let's see here. So that is chapter 8, where we talk about justifications. So we ended with consent. Then we had necessity as an affirmative defense or justification. We had officers' use of force or their ability or being justified because they're law enforcement. So that's what we call execution of public duties. Then we had defense of the home, defense of others, and then we started out with self-defense. So those are the 5 main what we call justifications. So without further ado, I've given you guys the website for the book. So just go to it, and if of course, you can ask me questions because it was kind of I wouldn't say quick, but I did kind of breeze through the material just to make sure I got it all out. But if I was too fast for you, or you need to hear it again, of course you can rewind it. Or if you have questions, you can ask me, and then we'll have a meeting, what we call a synchronous learning meeting anyway. So everyone be good.